Okay. All right. Hi, everybody. Welcome. My name is Andrew Chen. I worked at CCWRO for a long time, and now I'm at Housing and Community Development Department in their Housing Enforcement Division. But I told them I'd help out with this training, which is on Johnson v. Grants Pass. Some of you know the Supreme Court recently struck down the Ninth Circuit's case law on homelessness and the criminalization of homelessness, basically opening it back up for governments, whether that's state governments or municipal governments, to harass and abuse unhoused people by taking advantage of laws that make it illegal to exist outside or to do normal human activities outside, basically. So yeah, let's get started. First, I think it's important to talk about how we got here. As some of you may know, the American legal system was based on the English common law, which was basically a body of law that originated with judges making decisions and then other judges coming on later on critiquing those decisions. And sort of, as opposed to like it necessarily being passed by a legislature, this was a body of law that sort of developed organically from the people and the judges who were judging it. Um, but one type of law that they did have on the books are called vagrancy laws. These actually originated back in the day because when there were famines and people would have to abandon their farms and villages, people would move from place to place. But those people didn't have extra mouths didn't want extra mouths to feed either. So they wanted a policy tool, so to speak, to be able to move people out of their village. And so those are sort of the medieval origins of this thing. However, as you can imagine, it quickly became an efficient way. If you designate people, if you designate outsiders and make it so that you can basically remove quote unquote outsiders for any reason, it's a very easy way to socially cleanse where you live, to remove undesirables, often ethnic and religious minorities and people with disabilities, that kind of thing. When England colonized North America and 13 original colonies came, those kinds of vagrancy laws came with them. Every state had them. They varied wildly from state to state, but generally, um, they criminalized, really vague kinds of suspicious seeming behavior, like, loitering or appearing suspicious, or, lots of other sort of antiquated style language. Um, that some of which trickle down to the present day, like you can see in this example statute from Florida, at the bottom of the screen. Uh, Rogues and vagabonds or dissolute persons who go about begging, common gamblers, persons who use juggling or unlawful games or plays, common drunkards, common nightwalkers, thieves, pilfers or pickpockets, etc. This is very old-timey language, very antiquated language, but the impact that it had on people was very real because this kind of language was essentially just an attack on character, right? There's nothing, there's not a lot of behavior being outlawed here. This really allowed law enforcement to basically harass anybody they thought didn't fit in and get them to move on, or just to commit violence against them. Um, uh, So there were two Supreme Court cases that would make it for states to use different vagrancy laws, and I try to think of this historical precedent as sort of questioning the constitutionality of these vagrancy laws from two sides. And we're going to talk about those two cases now. First, there's Robinson v. California, which came in 1962. And that held that a California law criminalizing drug addiction was a violation of the Eighth Amendment's prohibition against cruel and unusual punishment. And it basically said that if you are punishing specific inherent status, such as medical status, addiction status, disability status, it's cruel and unusual because you're punishing something that's ultimately involuntary. Um, and I like to think of that as sort of pressuring the constitutionality of vagrancy law from the specific side. It's saying, well, you can't target two specific things because that shows discriminatory intent, right, or effect. It's discriminatory if it's too specific. And then in 1972, a decade later, in Papa Cristo v. City of Jacksonville, it struck down the Florida statute from the previous slide. I'll go back to that really quickly. And as you can see at the bottom of the screen, this sort of is a challenge to the constitutionality of these vagrancy laws from the other side, right? This one is just too broad. It allows people to abuse their discretion, law enforcement to abuse their discretion, judges to abuse their discretion, because it captures too wide a net. And so this is why I think about the Supreme Court sort of starting to pressure these laws from both being too specific and being too general. So we'll talk about Robinson in depth. The California law in question said that no person shall be or be under the influence of or be addicted to the use of narcotics, excepting when administered by, medical professionals. Robinson, who is the plaintiff in this case, African American man, was stopped by the LAPD, who, in their sort of stop and frisk, looked at his arms, found track marks from what they thought to be heroin use. When he was stopped, he was not actively under the influence or suffering from withdrawal, so that's important, right? Because it means that he was basically arrested just for being an addict. There wasn't any specific behavior at play here. The Supreme Court, Justice Stewart writing, said, in the light of contemporary human knowledge, a law that makes a criminal offense of such a disease, addiction, would doubtless be universally thought to be an infliction of cruel and unusual punishment in violation of the 8th and 14th Amendments. A little bit better times at the Supreme Court when there was sort of some more common sense around compassion and the plain meaning of these kinds of things. There is a concurrence from Justice Harlan that focused more deeply on how on sort of the science behind the modern medicine behind addiction, and really specifically about why punishing somebody for having an addiction is cruel and unusual. And he said, we would forget the teachings of the Eighth Amendment if we allowed sickness to be made a crime and permitted sick people to be punished for being sick. This age of enlightenment cannot tolerate such barbarous action. Like I said, better times. More optimistic times for sure. Um, and then Papa Cristo was actually the result of 5 different consolidated cases that were all lumped together. So the first thing is you have Papa Cristo that the case is named after, along with 3 other people in a car. Notably, the defendants were 2 black men and 2 white women, and this was in Florida in the 70s. So you can imagine that there was a lot of racism and bias and involved in this stop. They were charged with vagrancy for prowling by auto, and that basically just meant driving around. The second case that was consolidated is there were people who were being charged with being vagabonds. Henry Edward Heath and a co-defendant were arrested for being loiterers and common thieves. And somebody was also charged with disorderly conduct. And the court, Justice Douglas writing this time, said that the statutory scheme, the case in Florida, the law in Florida permits and encourages an arbitrary and discriminatory enforcement of the law. It furnishes a convenient tool for harsh and discriminatory enforcement by local prosecuting officials against particular groups deemed to merit their displeasure. The poor among us, the minorities, the average householder, are not in business and not alerted to the regulatory schemes of vagrancy laws, and we assume that they would have no understanding of their meaning and impact if they read them. Nor are they protected from being caught in the vagrancy net by the necessity of having a specific intent to commit an unlawful act. That's a really long way of basically saying that the statute is too vague. If normal people going about their lives aren't on notice as to what specific kind of conduct is illegal and what specific kind of conduct is illegal. They can't sort of comport themselves accordingly. And that's a big part of the reason that the court found it to be unconstitutional. Um, like I was saying before, these 2 decisions work together to pressure the constitutionality of these laws from both sides, right? Um, so after these decisions, municipalities had to try to thread a needle. They really wanted to continue using criminal law to push people that they deemed undesirable out of their cities and neighborhoods, right? They really wanted to do that, but they had to sort of go between the Scylla and Charybdis, as it were. They had to really thread a needle between being too specific, right? So they didn't want to violate Robinson, and they didn't want to be too broad and violate, Papa Cristo. And Johnson v. And these laws sort of laid as they were at the Supreme Court for a long, long time. There were, a few cases that came down in the decades since then, but most of those, sort of they didn't really address the heart of the issue. And these two cases were the law for a long, long time. And Johnson v. Grants Pass is one of the first attempts for our legal system to determine sort of where the line exists. What kind of laws are permissible in between these two cases, for government to make these kinds of vagrancy laws. So, in the wake of these two decisions, many states attempted to pass what some people call like vagrancy plus laws, where they would have vagrancy language, right? They would say that loitering is illegal or wandering about is illegal, but they would add conditions to them. They would say, like, oh, if you're disobeying a police officer when you're doing that, that's when that's unconstitutional. Or, like, oh, if a police officer asks for a satisfactory explanation, quote unquote, and you can't give one, that's when it becomes illegal. Um, there are some more examples here at the bottom. As you can see, that they forbid like a type of conduct, a really broad kind of conduct, right? But they are sort of creating a context for more specifics, where they're saying, well, the circumstances have to justify, a reasonable alarm for immediate concern, right? Or you can't be hindering the free passage of any person. Um, and notably, what you might think, like looking at these examples at the bottom, is that it doesn't really solve the problem, right? Like you're still having a really, uh, 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 you're still basically writing a blank check for law enforcement to harass people that they don't like. And that was, the result. That is what happened. Specifically in California, one of the best examples of these kinds of laws is Los Angeles Municipal Code, Section 4118. I don't know if some of you are in LA, but if you are, you probably know this really, really well. It has been a big deal and a big point of contention for advocates in LA for a really, really long time. Um, Specifically, it has been updated a bunch of different times. It has been challenged in court a bunch of different times. And the current prohibitions basically say that you cannot sit, lie, sleep, obstruct a sidewalk outside um, by in certain places, right? So they're saying, well, you can't impede passage, or you can't be within 10 feet of a driveway, or you can't be within 5 feet of an entrance or exit, or within, a short distance of a fire department connection. Um, and what this has basically led to is a really bizarre sort of patchwork map of Los Angeles County or Los Angeles City and where people are allowed to sleep. And so there are actually resources online that have, sort of block by block, foot by foot, have sort of outlined like where exactly it's legal for people to stay. Um, and of course, it's not like the police are walking around with tape measures, right? Like this still creates a really intense pretext for law enforcement to stop people for simply trying to, exist and survive. Um, and notably, you might consider, well, like this law seems sort of facially neutral, but what's important is that it's intended to be specifically enforced only against unhoused or homeless persons. I lived in LA for, oh gosh, how many years? Like 5, 6 years. I went to the beach a lot. I sat outside on benches and leaned against walls a lot. I was never stopped by the police for sort of being on my phone outside of a business. I was never stopped by the police for just sitting on the beach like enjoying myself, or having to be close to a driveway or something like that. They just asked me to move, right? So these kinds of laws really are only enforced against unhoused people. And the Ninth Circuit's modern jurisprudence sort of got at the heart of that issue, right? Like they sort of saw through the artifice and saw that like these laws are really just there to punish homelessness. They are not there to regulate the general public. They only exist to target a specific subsection of the population that that the city deems to be undesirables, right? And so the National Lawyers Guild and ACLU brought a case challenging 4118D specifically. And in 2006, it went up to the Ninth Circuit. Um, and citing Robinson, the Ninth Circuit Court of Appeals said that 4118 violates the Eighth Amendment, um, saying that these decisions lead us to conclude that the enforcement of this 4118D, violates the cruel and unusual punishment clause. And that's because shelter is unavailable, right? They were saying that, well, if there isn't public shelter, and you are punishing people for sleeping outside, like that's cool and unusual. People have to sleep somewhere. Sleep is a life-sustaining activity, and if you're not giving them a place to stay, then you are punishing life-sustaining conduct, and that's cruel and unusual, right? Unfortunately, this case, Jones v. City of Los Angeles, was retracted, and I'm still fuzzy. Actually, I looked into this for a long time when I was living in LA, and I was still not quite sure like exactly how this happened. But the city and the plaintiffs ended up settling, and they ended up uh, saying, well, like we won't enforce this if the city constructs 1,250 units of permanent public housing. That is drastically uh, not enough housing to solve homelessness in LA, even in 2006 or 2007. So I'm still not sure to this day what really happened there. But so Jones v. City of Los Angeles is not actually precedent in the ninth. It's not binding precedent in the Ninth Circuit, but it was an important rhetoric. It was important writing, and that kind of reasoning came up again in Martin v. Boise, which is the law that um, sort of set off the chain that led us to our current moment. So in Martin v. Boise, the Ninth Circuit reiterated that insofar as it imposes criminal sanctions against homeless individuals for sleeping outside on public property, when no alternative shelter is available to them, they're unconstitutional. Um, this, and then in Johnson v. Grants Pass, that ruling was expanded to also cover civil punishments that are intertwined with criminal penalties. So one of the ways that Los Angeles, for example, like has tried to get around um, the constitutionality of these laws is they've said, well, like it's just a ticket, right? Like it's a traffic ticket, so it's not really it's not really criminal, and that's not true, right? Because speeding tickets, traffic tickets, if you don't pay them, you can have bench warrants out for your arrest. Um, you also, that debt is really punishing. Often it's hundreds of dollars, can go to collections. It's not a tiny punishment by any means, strictly because it's not like connected to a misdemeanor or a felony. Um, and in Johnson v. Grants Pass, the Ninth Circuit also noted that simply like separating a criminal statute into two steps, right? Saying that like, well, there's civil penalties, but if it continues, we can arrest you. Like that doesn't cause it to skip, constitutional review, right? You can't just like, it still triggers the kind of scrutiny that the Ninth Circuit looked at in Martin v. Boise and Johnson v. Grants Pass. Let me just check us on time here. Okay, great. Plenty of time. Um, so the Supreme Court took up Johnson v. Grants Pass. The city of Grants Pass appealed it to the Supreme Court. Notably, a lot of California legislators and local politicians, including Governor Newsom, including Mayor London Breed and Mayor Todd Gloria, as well as a bunch of other local legislators and local other stuff, signed on to the case that the city of Grants Pass brought before the Supreme Court. And this is the modern ultra conservative radical Supreme Court. This is the court that struck down Roe. This is the court that's trying to that struck down Chevron. This is the which is has to do with administrative regulation. This is the court that is trying to make it harder and harder to join a union. And our California politicians decided that what we should do, we should really sign on with that court's agenda. We should try to really be part of their political project. And if I sound very angry and bitter about this, it's because I am. California politicians want to be able to criminalize homelessness to demonstrate that they're doing something about the issue to frustrated constituents, right? Like, I think we all know, as advocates, that people don't like Oftentimes when we're talking to people who don't work in this space, people talk about, visible poverty, right? Like they get unnerved by seeing people who are struggling outside. They sort of want to like go about their lives and not have to think about that kind of thing. And while, that may be an understandable impulse, it's not a pleasant thing to think about. It doesn't mean that you can, use the power of government to move them from sight just because, right? And so you've ended up with this really sort of bizarre coalition, because California politicians do feel a lot of pressure, even very, very liberal politicians, very ostensibly progressive politicians, feel a lot of pressure from their constituencies to quote unquote do something about this issue. And so on the one hand, you have, various civil rights groups, the government of the United States, to their credit, the Biden administration, has taken the Ninth Circuit side on this, basically, with sort of a few quirks that aren't really worth getting into. But, the Solicitor General argued on behalf of Johnson, at the Supreme Court, in addition to the attorneys representing the unhoused persons, right? So you have unhoused persons, their attorneys, legal aid, civil rights group, and the government of the United States. Like pretty solid coalition, right? On the other hand, you have a bunch of cities, a bunch of counties, the Pacific Legal Foundation, law enforcement unions, chambers of commerce, and groups of concerned citizens that I characterize as neo-fascists because they're basically just concerned about the presence of a low-income or fixed-income people and minorities in their communities. I think we've all seen these folks. And so those are the two coalitions, right? And the latter coalition is the one that our governor and um, a bunch of our politicians decided to sign on to, and I think that's interesting. Um, so next, if for those of you who may be unfamiliar, when a case goes to the Supreme Court, first the court has to say they're going to review it, which is called granting certiorari or cert. And then after that, they have what's called oral argument, and that's where both sides get to sort of go before the full court and make arguments about, why they think their position is the correct one. And it can be a really illuminating phase of the case because you get to see directly what the justices are thinking. The justices will ask a lot of questions, um, and you sort of get to see sort of like how they're thinking about the problem, like what kind of decision might they make. And one thing that really came out of that oral argument was that the conservative majority was very concerned with the line drawing problem that we sort of touched on earlier. What is the line between status and conduct? One of the examples that I think Neil Gorsuch used this example where he was basically saying like, well, if somebody stole bread because they were starving, like would that violate the Eighth Amendment, right? Like, is there a Jean Valjean Les Miserables exception for under the Eighth Amendment? And counsel for the Johnson, who is Kelsey B. Corcoran, who is excellent, excellent, excellent. And I highly recommend just going back and like watching that argument or listening to that argument rather, since it's just audio, and listening to the way that she talks about these issues, because I think it's a really she does a really good job of sort of zealously maintaining the interest of her client while sort of adjusting her rhetoric to accommodate for a group that is sort of baseline politically speaking probably going to be opposed to what to her position and her perspective, right? And she had a really good answer for this Eighth Amendment stealing bread issue, where she was saying that, like, well, stealing food to eat or starting a fire when you're cold, in a place where you're not allowed to start a fire, imply underlying criminal conduct, right? So there's like two steps. They're saying like, well, theft or starting a fire, where you can't, is illegal for everyone as sort of an underlying basis. And then if you were to add sort of the starving layer to it, the starvation layer to it, or the freezing layer to it, like that's another circumstance that's sort of layered on top, right? And so you have the specific circumstance of somebody, the mitigating circumstances of somebody stealing to eat or lighting a fire to stay warm, but underneath that there is, there are theft laws and there are arson or fire laws that apply to everybody, very neutrally. Sleeping in public is basically only criminalized for homeless persons, as is evidenced by the legislative and enforcement history, right? Where, like, although this may be like facially neutral, like we know why these laws are being passed. We know like who the cops are stopping. They are not stopping people who are napping on a bench, with who look like they are, fully housed, right? Um, and I thought that was a really good answer. The three liberal justices on the Supreme Court, Justices Sotomayor, Kagan, and especially Justice Jackson, really did a good job trying to keep the discussion on track and redirected the narrative away from these sort of nebulous line drawing hypotheticals that can get very sort of impersonal and detached, and really getting back to the core of the issue, which is that the Supreme Court's the precedent that binds it, the Ninth Circuit law, applies really squarely in this case. Um, and then the law basically allows for reasonable time, place, and manner restrictions on public behavior without permitting laws prohibiting existing as a homeless person in public. So you can prohibit other kinds of conduct. There's plenty of ways, they were saying, uh, uh, to regulate public behavior uh, without violating the Constitution, right? And Justice Jackson said in particular, which I thought was a very powerful example, that criminalizing universal attributes of homelessness, sleeping in public, was akin to basically making breathing illegal, right? Like you are de facto, trying to make it impossible for people to live in these areas. Um, and then Justice Jackson also noted that the Oregon legislature recently passed a law that making Martin v. Boise and Johnson v. Grants Pass into state law, right? And so effectively, the case should be mooted because there's no longer a controversy, right? The Supreme Court is only allowed to decide cases where there's an active case or controversy. That's built right into the Constitution. And when there is no longer a case or controversy, the case becomes moot because there's nothing left to decide. And I think it should have been mooted at the first place because, like Justin Jackson said, the Oregon legislature basically said, you know what, we agree with the Ninth Circuit. That's the kind of law that we want to have in Oregon, and um, they passed it. So whatever the city of Grants Pass wanted to do, whatever the city of Grants Pass thought the law should be, it was overridden by the Oregon legislature. So it really should have been mooted at the start. But oftentimes, unfortunately, these sort of procedural technical details, like mooting a case for a lack of case or controversy, is are um are soft. Oftentimes judges, especially um these appellate court or Supreme Court justices will choose to ignore that, and they will decide that, well, the issue is too important, like we have to decide it, because it's important for the rest of the country. But I think it should have been mooted. And Johnson v. Grants Pass got struck down. There was a 6-3 decision, with the liberal justices dissenting. The main through line that the conservative majority said was that the enforcement of generally applicable laws regulating camping on public property does not constitute cruel and unusual punishment prohibited by the Eighth Amendment. Um, and they really went to sort of an older view of the Eighth Amendment there. As we know, the conservative majority on the Supreme Court likes to appeal to what it calls original meaning, when it suits them. And here they went back to sort of a traditional understanding of cruel and unusual punishment by saying that, well, simply criminalizing, camping on public property doesn't is not designed to cause, quote, terror, pain, or disgrace. I disagree about that. And then I even disagree about that, but they also said they have been among the, quote, usual modes for punishing criminal offenses. Because you're talking about limited fines and limited jail terms. So they were saying, well, the underlying the underlying offense is not designed to terrorize people, and the punishments are not too bad, so it's not cruel and unusual. Um, and the key quote from the dissent that I really like said that this court too has a role to play in faithfully enforcing the Constitution to prohibit punishing the very existence of those without shelter. I remain hopeful that someday in the near future, this court will play its role in safeguarding constitutional liberties for the most vulnerable among us. Because the court today abdicates that role, I respectfully dissent. Um, at
I'm
this point,
sorry, Andrew, who said
yeah,
that last part?
I
Which
think that's
justice?
Justice Sotomayor, I believe, did the.
Sounds like something she'd say.
Yeah,
Thank you. I'll
yeah,
look it up.
yeah. Let me double check. Just a second. That's Justice Thomas. Yeah, Justice Sotomayor. Mm-hmm. Yeah, that was Justice Sotomayor.
Love her. Thank you.
Yes. Yep, you're welcome. Okay. Um, and important from a policy perspective, not only are these kinds of laws really cruel, not only are they stigmatizing, not only are they constitutionally impermissible, but they also don't work, right? It's also not effective policy, and I think that's an important thing for us as advocates to always sort of have in our pocket. Is as sort of the 1-2 rhetorical punch. Where on the one hand we can say, well, the core moral issue of this, right, is that it's really messed up and it's really unconscionable laws to sort of harass people and sort of push them out of public in this way, right? Um, but uh, Importantly, both research and the history of common practice show that these kinds of laws just don't work, and they actually make it harder for unhoused persons to find shelter and permanent housing. And we've known this for decades, right? This is really, really not new. Um, Incarceration and fines, make it really hard to maintain employment, to apply for loans, to complete education, and to purchase basic necessities like rent and food, as if you have money, going to, paying fines instead. Um, one when I ran a legal clinic for homeless youth in Venice, in California for 5 years as part of my responsibilities there. And one thing that was uh, really notable that I had not considered before I started doing the work was that if you don't pay one of those ticket fines, right? In California, these are like traffic tickets, right? You won't get a criminal record from them, but you can have debt. And that civil debt can go to collections. And if it goes to collections, it can show up on a credit report. And it can erode your credit over time. And so I had clients who, just through existing had, hundreds or if not thousands of dollars worth of tickets, often given week over week, often given for the same thing, without any offer of help, right? And so when they were trying to go apply for loans for school, or other stuff like that, they were told like, well, you have this warrant, right? You have this bench warrant. Oh, or you have this you have your credit score is really bad, and so we can't approve you, um, right? Uh, it, so that was just a really sort of like messed up sort of wrinkle of this that I think we don't often think about. One detail I always like to talk about also is that at least in LA, the paper that they write the tickets on is like carbon copy, right? Like I don't know if we have some younger folks here in the presentation that might not know what carbon copy paper is, uh, but I think most of us probably do. It's basically like you write on it and then it makes an impression on the paper below, so you can like give a copy to somebody, right? And that carbon copy paper smudges so easily that if you were to fold up the ticket and put it in your pocket, it would basically be unreadable within a day. And so I saw this also all the time is I had to go online and go to court and look up people's tickets because when they would give me the tickets that they had that they'd put in their pocket because like that's where you would put it, you'd fold it up and put it in your wallet. It had literally smudged beyond recognition, and I couldn't see what the offense was for, what when it had been given, right? So I don't know like what their timeline was like. I didn't know what courthouse they were supposed to go to. I didn't know the name of the officer who gave it, right? And those are all really important things to know. And if you don't have access to the internet or don't know that you can just go and look that up on the court website, you have no idea where you're supposed to go up and show to court. And most people, vast majority of people I met, did want to address their tickets. They did want to go to court, but they just didn't know how to do that. Um, uh, yeah, it's also important to note that marginalizing and pathologizing poverty further isolates unhoused individuals, and it destroys trust and progress that people like us, nonprofit and government service providers make. I think we all know through our experience that making those relationships is really hard sometimes because you're talking to people who have literally been betrayed by every institution or person that they've interacted with for decades over decades. In addition to underlying mental health conditions or addiction conditions, or other trauma, right? Like it's really hard to build those relationships. And when you have these laws on the books and you have police showing up and sweeping or harassing people, it makes it really difficult to maintain those. Sometimes, I'm sure some of you know, just figuring out where people are. Um, like it's really difficult if there's a street sweep, right? And somebody's tent is moved. you don't know where they went, and they might not be able to show up at your office on their own, or they might not be able to show up at your clinic on their own. And so when I was doing the ticket practice, there were a lot of times where after the initial retainer agreement, I would do my best to keep in touch with the client, but I would, not talk to them until the issue had already been resolved, just because it was so difficult to keep track of people in an environment where they're constantly being moved from place to place, and they're constantly being sort of forced to appear invisible, right? I think one thing that is more commonly known but is worth bringing up is that street sweeps also destroy vital records, birth certificates, medical paperwork. I know as many of you do benefits work as well. Having that those medical records and the birth certificate and stuff like that, identity is really important to maintaining benefits, especially if, say, you're trying to upgrade to SSI or something like that. That's a long process. You need to have those documents. And this is obviously in addition to medication and life-saving supplies. I'm sure we've all had clients or have known people who get swept and they can't take their diabetes medication, or they can't take their psychotropic medication. Other things where you really have to stick to the regimen, or it can be really dangerous, right? um, I remember early on in my career being at a public benefits office in LA, and I was talking to somebody who um, uh, basically could not afford their diabetes treatment because they could not you could either have, there was a more expensive kind of insulin that didn't require as much refrigeration, or maybe refrigeration at all, and the less expensive kind needed to be refrigerated at all times, right? And so because this person didn't have access to a refrigerator, and because they were being moved from place to place, they couldn't take their diabetes medication because they couldn't preserve the integrity of their insulin, right? And so, for unhoused people, who are struggling with addiction or mental health problems, criminalization can, undo months or years of progress made by caseworkers and medical professionals, because you've built up this body of vital records and supplies and medication, and it can all just be gone because some street worker decided that it was, that they weren't going to look inside the tent, before they threw it out, or they were just going to throw away the backpack without, talking to somebody, right? Um, and it's not like these street crews wait for people to be there. It's not like they give them a notice, and then if they're not there, when they show up, they just throw everything away. And as you know, often people have a lot of other obligations. People are working, people are going to appointments, oftentimes they're walking or taking public transportation, so they might not be, at the place where they're staying, exactly at the time that it's being swept, and that can have really, a devastating consequences. And one other point that I like to throw in, not because I think it's the most important, but because I think it's rhetorically impactful in an environment where people don't like to spend money on poverty issues, or public benefits, right? Is that criminalization is also more expensive than simply providing services. We've seen this in the Housing First model, and we see it here also, because the costs of involuntary commitment, or putting people in jail, or in criminal prosecution, uh, or even just paying the overtime for the police to sit in court, when you challenge the tickets, that all adds up, and it's really expensive, and it's more expensive than just simply providing services um, for people. So we're getting to the end of the formal presentation, and because I want to leave some time for questions at the end. And so, the Supreme Court did not uphold, they overturned the Ninth Circuit precedent. And so we can expect, that sweeps and vagrancy plus laws are going to become much more common. We're already seeing this in San Francisco, we're already seeing this in LA. Basically, before this, there, at least a lot of these officials sort of needed to have a sort of respectable veneer of like wanting to provide help and wanting to provide services for people. And I think all that we've seen now is that sometimes they'll still say that, but both in substance and in rhetoric, these politicians are feeling a lot more comfortable saying, well, like, people just have to go, or, oh, people just can't stay here. And it's because they've been protected by the Supreme Court now in order to make and implement those kinds of laws. Um, and so I don't know exactly what the way forward is. I think that advocates need to continue to push for the kinds of policies and programs that would really help people. Whether that's universal basic income, whether that's a housing guarantee, increased public housing, rent control, right to counsel in a landlord-tenant environment, uh, you know, um, vacancy taxes on or short-term rental restrictions, all those kinds of things to help preserve housing supply. But what I really worry about is that like we don't have a lot of outside of simply funding programs. Like this case has really removed a big legal avenue that we had to directly advocate for people who are unhoused, right? Where like we have a lot of policy tools that sort of increase resources for people, but it's also important that we just protect people's rights like at a baseline, right? And it is a lot more difficult to do for that now. um, and so I'm not sure what the way forward is. If any of you have suggestions or questions, I think we all need to get together and start talking about this more. um, yeah, so unfortunately, we're in kind of a precarious place, and I think what makes it feel dangerous to me is that it's a bipartisan war against the unhoused population, right? Like we're not just talking about conservatives in red states. We're talking about very popular politicians, Democratic politicians with large audiences who govern large parts of the state. And it is really disappointing and very scary. And it's going to be a heavy lift to sort of figure out, like, well, like, how do we push back against this politics, right? I've been encouraged in some ways in the current presidential race by the kind of rhetoric that Governor Walz uses when he talks about these issues. I think CB brings a very sort of plain spoken, common sense, compassion, where instead of, he likes to substitute neighborliness to talk about these sort of issues. And I think that's a really effective, at least rhetorical way to sort of change the way that Americans think about these kinds of issues and to get away from the sort of model that Ronald Reagan made sort of ingrained and burrowed into all of our brains, which is that there are deserving poor and undeserving poor, right? It's sort of getting away from that model and getting more towards the kind of model that Governor Walz talked about, at the convention and on the trail, which is that like no, like we have a compassionate, moral obligation to take these steps to help people. And I think that's probably the direction we need to move more strongly in next. But it really stinks that we are losing this legal arm for to defend the rights of unhoused folks. Um, okay, so I think we have about 15 minutes or so for questions. I'm going to go ahead and take a look at the chat. Let's see. So I'm looking at a comment from Adrian Lobby from Sonoma County Homeless Action. Thanks, Adrian. I'm really glad you liked the presentation. This is just a training. And so there will be a recording of the meeting that's going to go out from David as well as the slides. And I'll actually put my new email in the chat. Oh, and it's also important to note that I'm not here representing the Housing Community Development Department. I should have said this at the beginning, but I forgot. I'm just here as a personal citizen. I'm here on my lunch break. And so, feel free to direct inquiries to me. I'll actually give you my personal email for that so I'm putting my personal email in the chat. But yeah, feel free to reach out to me. I'm really interested in doing some greater advocacy and getting us all talking to each other. Um, but yeah, also seeing a question via DM from Daphne who says that is there a place for the argument that government agencies create homelessness with the policies and rules that discourage or slow down the construction of affordable housing resources? Yeah, I mean that's definitely part of it, right? Permitting is part of it, restrictive zoning is part of it. Um, all of that contributes for sure. Yeah, not passing resources to allow, people to build affordable housing, not releasing, vacant properties the government holds. That's all part of it for sure. Um, but at least as it regards, the actual substantive rights of people who are existing on the streets, like which they have like a right to do. Like it's Um, I think it's also important that we try and find strategies to help, those folks as well. Before, if, whether, like, regardless of their housing status or whether they're on a list for shelter or anything like that. Um, yeah. Any other questions? You can also feel free to unmute yourself and speak up. It doesn't have to go in the chat if you don't want to.
So I've been somewhat encouraged by the activism of around this issue, and I was at a statewide meeting of included cities and counties where there was just, I mean, I don't think anyone said, "Oh, thank you for doing this, Governor." They were
Mm-hmm.
all at the most questioning it, and some of them pretty directly saying this is a disaster. Um, there is a statewide summit in Sacramento on September 7th, and I'm going to put information on that in the chat if that's okay with everybody.
Yeah, that would be wonderful. Thank you. I did not know about that. That's good. That's good news. So this was a coalition of like locals who were coming together about this?
No, so
Local
there's two things.
electeds or? Uh,
There were two things. One was a statewide presentation, came through ICH, if you know what that is,
mm-hmm,
uh, who were trying to just like, here, let's explain more what the governor's order was.
mm-hmm,
And then they had, 20 minutes, but only city and county people could speak. So these were not people like me who just
mm-hmm,
like were up in arms, but they were
mm-hmm.
pretty much up in arms.
Yeah,
Uh, the summit is, I think, more of a grassroots advocacy group of people who put it on. I don't know them personally, but I put, like I say, the information in the chat. People can check it out for themselves.
yeah. Please send that. That would be really useful. I would like to be a part of that as well. Any other questions? All right. Well, thanks everybody. Looks like we can get you out of here a little bit early. Um, if you have any questions or have any follow up, my personal email, unifin at gmail.com is in the chat. Um, uh, there will be a recording of the presentation and the slides are also going to be sent out. Yeah, feel free to reach out if you have any questions. I'd also love to connect and talk with you all, more to try and organize a bit better because I do think the best way forward for us is going to be through organizing and being loud and being disruptive and really pushing for the kind of change that we want to see. Yeah, and I see Adrienne has put the information about the summit on September 7th in the chat as well. So y'all should check that out.
Andrew,
Yeah. Uh-huh.
no, you cannot leave 10 minutes early. If no one else has questions, I want to ask you a question.
Oh, sure, sure,
I,
sure. Yeah, sure. Yeah, no,
uh,
feel free. Go right ahead. Yeah.
so, on a local level, I live in Sonoma County.
Mm-hmm.
It's theoretically liberal, but we've had a lawsuit against the county and the city for their sweeps and the way they treat people.
Mm-hmm.
They have not been easy to work with on it. We are pushing for them to have a policy around what are they going to do given the Supreme Court and the governor. Do you have some advice for what kind of language we would want a city and county government to put in their policies? What's a good activist language we should use? Any advice?
Yeah, so I think this is where I think that um the Ninth Circuit precedent is actually really useful in terms of looking at specifically the kind of language to use and the kind of policies to craft. Um, I don't have it off the top of my head, but I know looking at the Oregon law for sure that they passed, codifying that would probably be a good model statute. Um, I haven't looked it up myself, so I don't know exactly what it says. Um, but that's definitely they're one of the only places in the country, if not the only place, that has really like codified these things and put it into law. I assume it would look something like our state shall not make a law, um, you know um, criminalizing life sustaining action, right? And you can list examples like sleeping or eating in public, etc. You know, um, either you can either just have it be direct, right? Like you can have it just flat out prohibited, or you can adopt the sort of more specific Ninth Circuit language and say, like, in the absence of enough publicly available shelter, right? So you can say, like, if the point in time count, exceeds the number of shelter beds, you know, by X, exceeds the number of shelter beds, period, then, the police department, shall not, either the policeman department is not allowed to enforce these laws, like, or like, that may be a way to do it, or that, such laws are not allowed to be passed, right? So you can either prevent those on the front end from being passed, or you can also bind, the police department and other things like that. And that may be making enemies that you don't want, but I don't think, they're probably on the wrong side of this anyway. So I imagine that, like, yeah, I imagine it would probably look something like that. Part of the issue is that you do sort of have line drawing problems, right? Like, it is, that is an issue with this, specifically because, like, the problem is the intent, right? Like, the problem is the prejudice, and the discrimination. And so there are, as we all know, there are tons of ways to write laws that are facially neutral while still having a discriminatory effect, right? Um, and so I think it's probably difficult from sort of, like in the first instance, to write a law saying, like, laws of this type shall not be passed. Um, but I think it's worth trying for sure. And yeah, I take a look at that Oregon statute. I'm sorry that I don't have that language available right now, but I assume that that's probably, a good place to start.
Great. So next question. I know that Fresno has, I saw a news report saying that they have decided to do this kind of aggressive sweeping.
Mhm.
I wonder if anyone knows or more about that, and or if there are any other places that have already, putting this kind of thing into effect.
Yeah, I don't know about Fresno specifically. I mostly know about, like, San Diego and LA and San Francisco. I think LA has been a little bit better, um, is my understanding, than San Francisco and San Diego about these things. In Sacramento, I have heard that where I live now, I live in Sacramento now. I've heard that there have been more aggressive sweeps, but I don't have hard information on, like, where that policy is coming from, whether it's just, sanitation and Sac PD, deciding to go out more often. I'm not sure what the chain of command looks like in terms of who's making those decisions. So if other people have information about that, that would obviously be great as well.
Yeah,
Yeah,
one of our local activists have said that LA has actually resisted the governor's order in some kind of formal fashion.
Hmm.
I hadn't heard that, so if you
Yeah, I
have
know. I
or
know
any
Mayor
or
Bass.
have,
Yeah, Mayor Bass, at least rhetorically, has pushed back against the governor's order. In terms of what's actually been happening from the people that I know in LA, like LAPD and sanitation have sort of stepped up their efforts. I think they have felt emboldened, and but I don't know how much direct control the mayor has of that, right?
uh-huh.
Um, so at least I think, as far as what's actually unfolding on the ground, I don't think there's been a significant, like, change in policy. I don't think Mayor Bass's office, as far as I know, has issued any directives saying you need to sweep more. But I have heard anecdotally from my friends and former colleagues that live down there that, there have been, LAPD in particular has just felt much more free, and the sheriff's department, LAPD and the sheriff's department have both felt more free about, giving out citations in particular. Um, where when I was, so I my clinic was based out of Venice at a really wonderful little organization called Safe Place for Youth that does, that's a drop-in center, and I ran it there, and I ran that clinic for years, and by the end of it, like, there's a judge in Santa Monica traffic court who ended up really liking me, and she ended up, like, taking my side over the cop side, which, those of you who have been in court for that, is kind of insane. Like, that never happens, right? And the cops basically, LAP, the Pacific Division, almost stopped giving tickets, like the volume of tickets, like, year over year, because, like, I and my colleagues were in court, like, making life miserable for them and making every cop show up on every single ticket, which is expensive for the department, and also was annoying for them. Um, even though some of them really like just sitting in the jury box doing nothing, um, but because of that pressure and because of the how we were able to sort of gum up the system, they basically stopped giving tickets. But unfortunately, I think in recent years, like, sort of as I was forced to take a different job, not forced, but I ended up taking a different job, and I don't know like whether that ticket coalition that was in LA has really been still going. But I think, and that in addition to the Supreme Court news and the backing at the state level, if not from Mayor Bass's office, but maybe but from other places, has really resulted in a lot of more tickets being given now. Um, so I actually do think that like if you're a lawyer or work with a legal team, I do think that like taking the time to challenge these traffic tickets can be a very effective form of advocacy, because like especially if your client is willing to show up in person, to court, like it's very humanizing. To sort of be able to tell their story and provide, mitigating evidence in terms of, things they may be dealing with or programs they may be involved with, and oftentimes, to their credit, as maybe as reticent as I am to give it, like, officers, at least um, um, in LA, officers, at least in LA when I was there, were often willing to dismiss the ticket. There were very few times, vanishingly few times, where I really had to fight them for that. Um, uh, Most of the time, and it's because, like, for them, they're not really issuing it in order to get a specific penalty, right? Like it's about harassing the person. And that is accomplished whether or not the ticket is followed up on the back end or not, right? Like they've already done like what they need to do, and they've already shown the the business owner in the area that they're there and they're doing something about it, and so they didn't really care that much about like dismissing the ticket on the back end. But I did find that the ticket clinics, oh, like Tessa in the chat is talking about, which apparently good. I'm glad that they're still being that it's still being run. Um, but I did find those to be like a pretty good um, sort of grassroots way for lawyers to really sort of pressure and push the boundaries on these legal systems to make sure that you can't just hand out tickets willy nilly, because each ticket is a legal proceeding, and each person who that has due process, baby. And if you take advantage of that due process, you really start to strain the system in that way, which I think is a positive thing to do. Um, yeah, yeah. Thank you, Melissa. I appreciate you as well. Um, yeah. So, any other questions? We are at time.